Hello and welcome to today's podcast. I'm Susan Guthrie, your host, and today I was just telling my guest is a wonderful day because I am joined by the lovely and wonderful Claire Samuels. She is a friend and colleague who's beaming in from beautiful North Carolina, and I'm so happy to have her here. Thank you, Claire.
Thanks so much for having me, Susan. This is exciting.
We were just talking and I was saying, Mondays are not always my favorite days, but except that's when Divorce and Beyond podcast episodes come out. But I woke up this morning excited to have this conversation with Claire because I realized, although this is a topic that I know and is dear to my heart, I have not talked about on the podcast. And I think it's like really important, critical information for people to have. So I'm so thrilled and just to talk to Claire, but I'm so thrilled that she's here. As I always do, I want you to know that the people that you're hearing this information from are truly experts in their field. Let me just give you a little background on Claire, everyone, just briefly. Claire has been the high-end litigator, divorce litigator that you all, have heard of and know out there. She, for, I think it was the first, 10 years of your career, Claire?
13
years. Claire was with like the divorce law firm and worked for, you mentioned the partner that you worked for was named the most feared attorney and scariest person in Charlotte.
Yes, he made that top 10 list, which was intimidating to me when I started to work for him.
I can't imagine why, Claire.
Where did I land?
And that's who you ended up, learning from, right? You learned from one of the scariest attorneys in town. And really your firm, who I've gotten to know now, and I know some of the other attorneys who are there now, still lovely, lovely people, but it is very much in some ways a litigation firm.
Absolutely. Yes. That is absolutely what it's known for sure.
And you found at some point that, that wasn't really your path. And we're going to talk about your backstory from this, but just so that you all know, at some point, Claire, in early days, this is actually when you and I got to know each other, you transitioned from being a partner in that law firm to opening your own practice, which has blossomed and is thriving. And as are you in your new practice. And you have a wonderful new mediation practice and collaborative practice. And we're going to be talking about a specific aspect of that today. We're going to be talking about the fact that it's never too late to mediate, because what you do quite a bit of is mediation for couples who are involved in that traditional represented by attorneys divorce process. And they come to you at some point in the process and are able to mediate their case, even when it's like they're on the steps of the courthouse.
That's right. I would say probably 90% of my practice comes from lawyers who are pulling me into a case, sometimes a week before it's set to go to trial. So that is very, very commonplace that there are hearing dates or trial dates on the court calendar in the cases that we are trying to resolve and able to resolve at that point in time.
Well, and there's the key point. And so just from the very start of this episode, I want everyone who's listening to hear what Claire just said, that you are able to mediate and it works even when you're on the steps of the courthouse. Even when you have a trial date next week, you can still meet with a wonderful mediator like Claire with your attorneys and resolve that case. So we're going to be diving into what that looks like today. But I know, Claire, for many people, that's just a new idea right from the start for them, that they didn't even know that at any point during your case, you can always go to a mediator if you agree.
I mean, exactly. Like you said, it's never too late. people settle cases on courthouse steps all the time. I mean, the unfortunate part of that, right, as you and I know, is that at that point you have spent a lot of money. Things have probably gotten quite nasty. Some nasty motions or letters or what have you have been exchanged and gone back and forth. But that doesn't take resolution off the table. There's always, and sometimes there is the motivation that's needed to take that case all the way to settlement when people have done all of the discovery, gotten all of the stuff and information out there, and know that there's some real exposure, which there's always exposure, right? Every case has a blind side, is what I tell my clients. And part of mediation is not that one side is good or bad, or one lawyer's done a better job or another, or one argument's better or another, but every case has a blind side, and every case you have some exposure, and trying to poke holes in that at the last minute is really what sometimes people need to hear, to think I'm rolling the dice here once I walk through that courthouse door.
Yeah. Well, and having gotten to know you and knowing the level of your litigation practice, I imagine that is why your colleagues are reaching out to you to be their mediator for cases that are in that moment in time, because you've been the attorney pushing open that courtroom door, pulling the suitcase full of files, or having the team walk through with the boxes of files ready for that trial. You know what it looks like in that courtroom. And I want, my listeners to understand, the level of your experience. So let's just go back in time to when you started working for the scariest attorney in town. And, tell us a little bit about what a litigation practice was like, because you were a superstar. You rose up through the ranks of that firm like a rocket.
Well, thank you. It's intense, as you know. We've talked about the similar paths that we had to this point in time. It's very intense. I mean, I was fortunate to be learning from some of the best attorneys, in our city, in our state. There's no doubt about it. And it was an invaluable time for me to learn how to, hone my instincts and work really hard. But it's intense and sometimes really toxic when you're going to work every day, armoring up, figuring out how to write the most aggressive letter, take the most aggressive position, file everything is being on the offense versus being on the defense, whatever that ends up meaning in your practice. But it is a high alert, intense practice day after day that most lawyers behind closed doors will tell you makes them miserable and also makes their clients miserable. And I started feeling that fairly early on. I mean, it feels great, right, to get prepared and go into court and win a case, and your client is pleased. But that's just the beginning of the next cycle of whatever the next thing is going to be in that case. That's typically not the end, and it's just wash, rinse, repeat day after day. And I got tired of it.
Yeah, well, it's so true, right? I think, there's so much in that rings true for me, because I remember I loved going into the courtroom. Mm-hmm. I loved using my wits and taking the facts and the law and, working them together so that I could get the outcome that my client wanted. And yes, you're right? It was a victory in that moment if you could win. But what you often found as we pushed our way back out through the courtroom doors and back down the courthouse steps, what felt like a win just a few minutes ago, as you saw the couple walk off yelling at each other in the parking lot, or you saw one person upset and frustrated, or you got the phone call the next day that there was a huge fight at the drop off of the kids, you just realized that was not really a win. You had to redefine what winning looked like.
Right. Exactly.
I know for you at some point, you realized it was time to make a change, that for you professionally, there was going to be a better way to do this.
Yeah. I mean, I started to struggle really just feeling out of alignment with what I was doing and how I saw that it was impacting families. And, um, you know, the crazy piece of it is a lot of times, and I know that they think this is that a lot of times parents think that they are fighting for their children or doing what is best for their children, and you don't want to take anything away from that. But the high conflict that they get brought into, I am not a psychologist or a therapist, but they all tell us that it's just so traumatizing to them. And you see that play out, and it was just not something that I wanted to be a part of anymore, or that I really believe served my clients or their kids in ways that they were really looking for.
Yeah, and I think that is a common thread that we find in our field, as divorce mediators or family mediators. That many of us have, in fact, I think our last training course, out of 40 participants, 38 or 37 were divorce litigators who had that same light bulb go off. And one of the things that was really interesting, one of the things that they said is that sitting as a group and hearing from 36 other divorce attorneys that they were feeling the same thing actually just reinforced for them that there did need to be a better way for families, and there did need to be an alternate path. And that's why I think this conversation that we're having today is so important for people, because so often couples, when they go through that time of, do we get a divorce, don't we, and it's decided that that's the course the family is going to follow, everyone runs out, gets an attorney, and just automatically assumes that that litigation route or that traditional pathway is going to be how it's just how it has to happen. And so I know for people listening today, just hearing from you at the top of the episode, that right up to pushing through that courtroom door, they can go down a different hallway and meet with a mediator like you and resolve their case, and that works, is going to introduce hope for people.
Yeah.
But tell me, let's break this down into pieces. How do people get to you if they did want to mediate? How does the typical case come through your door? Who gets in touch with you?
Typically, it is.
Hi, Darlene. We're going to cut out that phone.
Sorry about that.
Don't worry about it. See, this is why the Darlene thing's awesome. So we'll just pick up from, and how do they get in touch with you, or how do they come through the door?
It's typically their attorneys are reaching out to me saying that there's a case that is in litigation, and I get the names of the attorneys and the parties and run a conflicts check like I would in my normal practice before speaking with a client, or a potential client rather. And we go from there in terms of selecting dates and times to figure out when we can all get together for mediation.
So explain for the people who don't understand the conflicts check. Explain what that is.
Sure. So the attorneys are letting me know that they are involved in the parties that they're representing, and ensuring that I also have a private practice where I still work as an attorney and represent clients. So making sure that I haven't either represented one party or had an initial consultation or a meeting with one of the parties, or am not connected to the parties in some way or another that would influence my ability to serve as a neutral mediator in the case.
Right. And that's a critical part, because for so many of us who did, especially you who have been in your community for so many years and who were with a large firm for a long time and now are still representing clients, it's important that that neutrality of the mediator be protected at all costs. And so right from the very start, part of your process is making sure that you are neutral and there are no conflicts with any of the parties who are involved, right?
Right, exactly. And I like to make sure that there's even, just the lawyers on the other side. A lot of times now I get calls from lawyers in my old firm. But the lawyers on the other side know that I came from that firm. So I kind of put that out there. If I think the lawyer might not know where I came from, most do, I will put that out there just so there's not um, any kind of appearance for them or their clients, because with Google, you can figure out where I was and, oh, well, Claire used to, and so I like to just make that really, really clear. And I typically even kind of go over some of those things in my first meeting with the clients and their attorneys to say that I've typically worked with both of their lawyers at some point in my career, either with them as law, people move in and out of firms. I was at the same place for a really, really long time, but people came and went. And that, I've either practiced law with or against most of the lawyers I work with as a mediator now. And so I think that's also helpful. It reassures clients that you have really good lawyers if you end up in a courtroom. But you now also have somebody here to help you try to extract you from that process and before you go that final round.
Yeah. And I think that's a really important aspect because if you've practiced in an area for a certain period of time, I was in Fairfield County, Connecticut for 26 years. There were very few attorneys I didn't know by that time. Most of
Right.
us knew each other. We were friends. I knew
Right.
about their kids. I asked about their parents. We had all known each other for a long time. That doesn't mean we can't be neutral when
Right.
we are working as professionals, but it does bring that added layer, right? The attorneys, the court system in the area in which you're practicing, you've been there, and at least from the perspective of what it looks like in the courtroom, so that you can bring that into the mediation room for the benefit of the parties.
Yeah, I think that it's all of that as a combination that really can be helpful. And knowing the lawyers on a personal level, and also having some understanding of how they practice, what's important to them, how I've seen them do things before, can also be an added little bonus for how we might work things out, or that kind of stuff.
Yeah. Well, and another thing that strikes me is you mentioned that usually it's outreach from one of the attorneys. I would imagine almost all the time one of the attorneys is reaching out to you. But I do want the listeners to realize that that process of getting to mediation can be started by the clients talking to their attorneys and saying, "Hey, is mediation an option for us?"
I mean, thankfully in North Carolina, our statutes, if you file a lawsuit in the state of North Carolina related to equitable distribution, which is property division in North Carolina, or custody, you're going to be required to participate in some kind of mediation or alternative dispute resolution process, either through the court system or privately with someone like me. And I don't think people know that. So absolutely having that conversation with your lawyer about, can we do this on the front end? Can we do this before we're ordered to do this? Can we do this before we're under court deadlines and things like that, and getting into the mediation room sooner? But again, it's going to happen one way or the other, and it can happen really close in time to hearing dates and trials, and is the way we see a lot of cases get resolved.
Yeah, well, let me first say bravo to North Carolina for having that in your statutes, because I will tell listeners the vast majority of states do not have a provision, at least when it comes to equitable distribution or property division. A lot of states will say before you can get into a courtroom on a custodial issue, you have to go to mediation private or through the courts. But equitable distribution is not usually mandated for mediation. So see me applauding, everybody. But for those of you who are out there who are not in North Carolina, know that even if you're represented by an attorney, early in your case, in the middle of your case, or as you're walking up those courtroom steps, you can talk to your attorney about mediating the case. So it may not be that your attorney is going to come to you and make the suggestion, although I hope they will. But if they don't, you can raise this with your attorney and see if it's a viable option for your case. So once you get that outreach, you've done your conflict check, Claire, everything's good to go. You mentioned you set up usually scheduling some times. Who do you meet with first? How does it get started?
So we all meet together. We typically, the attorneys let me know whether they think we're going to need a half, a whole day, 2 days. That's an interesting new trend I'm seeing is sometimes people want the 2 day block to have the first day and the backup day. Then on the date of mediation, typically we get everybody situated in their separate rooms. And then I typically like to chat with the lawyers just for a few minutes. I, at that point, only know the names of the parties, the attorneys, and the core issues involved in the case, and whether or not the matter is in litigation. So I typically like to chat with attorneys to see what has been done up to that point, perhaps if there are any hot button issues, anything that we want to really accomplish within the time limit we have, if anybody has time limits that day. So really kind of just a catch-up session with the lawyers. I do that for a few minutes. Then we bring everybody, assuming it is okay with both attorneys and there aren't any issues of, domestic violence or things that we're trying to keep people in separate rooms for any particular reason. We bring everybody together so I can explain the rules of mediation at one time, that it's a confidential process, that it is, that I'm a neutral, that I'm not there to make decisions, all of that kind of good educational stuff. So everybody hears the same thing at the same time. I tell them a little bit about myself so they know I'm not just a stranger. I'm going to be hearing a lot about their life in the time that we're together. So I like to let them know a little bit about me. And then I share with them why I think mediation is, an invaluable process and the best process for resolving family law disputes. Yeah. And then we separate. And I start wherever the natural place is to start. And I go back and forth until we reach a resolution.
So you do, I always call that the shuttle diplomacy. Yeah, I remember the days of doing that in my high heels, and I'd have my file and my yellow pad, and I'd go bouncing back and forth between conference rooms in our office space. Now I do everything online, so I can just click buttons and go between rooms. But I think an important thing that you just said, Claire, is even if you are on your way to court and you bypass or you take a detour to mediation, your mediator is neutral, not a decision maker. So yes, in a courtroom, you're going in front of that person in a robe who is going to make decisions for you, but very, very differently, even though you're ready for a trial. This is not a pseudo trial or a mock trial or a replacement for a trial. This is an opportunity to have discussions that are facilitated by your skilled mediator so that you can make decisions and agreements and come to resolutions, right?
Right, exactly. And that's, and we talk about that, right? That this provides an opportunity for creativity. Our judges have limited time and rules that govern their decisions. Here, we can come up with something specifically tailored for your family, for your circumstances, for your finances. We can take the time to create the little nuances that feel good for the two of you versus trying to put everything into a cookie cutter formula.
Well, and a lot of times the law prescribes an ending or a resolution to things. And that may not actually be what either of you wants. Whereas, as you were just saying, really, you can be creative and come up with, all kinds of things. And I think that's one area where you must be a huge help to people, because with your experience, of all these years in the field, the brainstorming and the possibilities are, you have things to add to that conversation they may not have ever heard of or thought of.
Yeah, I certainly hope so. And I think, now more than ever with people working from home versus now people going back to home, like what does that mean? Like school being in versus school being out. Like there's a lot of things that we have to think about related to kids that we didn't have to think about before. But also, I mean, even if you're in a case that doesn't have kids, that doesn't mean mediation, again, creativity with finances. Maybe, you have a base and a bonus structure that you're dealing with for support issues, or you need to pay something out over time, or, like to be able, again, to just not have it has to be done this way by this time, this manner, something that gets shoved on people that might not really work for them. Then you're paying lawyers to also try to negotiate that and clean that up and make it workable.
Yeah.
Mediation lets you solve for all of that.
Right. Well, and a good point, you mentioned cost. And I do think it's important that people know, yes, you are going to pay your private mediator. Your attorneys are going to spend time preparing for the mediation. They may provide information or written documentation to the mediator ahead of time. And certainly that half day, or 2 days of time will be paid for, but you're going to pay that if you go to court anyway.
That's right.
It's money that's going to be spent, and you may very well walk out of the mediation with a resolution that you chose what you can and cannot live with, as opposed to going to a courtroom, which you and I have both been in that courtroom. Claire, has your client gotten everything they wanted every single time you went into a courtroom?
No client ever gets every single thing they want to. And if you go meet with a lawyer who tells you they can do that for you, you've got real problems.
Yeah.
You are being sold a bill of goods.
It is not possible, because ultimately, even if you walk away with every financial thing, there's something about there's just no way in a courtroom to get the resolution that people are looking for. You'll still be missing the emotional piece. There'll still be something about the parenting piece. And by the way, no one gets everything that they want financially in a courtroom or in a mediation. Let's talk about that.
That's right.
I mean, in a mediation, compromise is the name of the game.
Right. But it's compromise you choose versus it being shoved on you, right? Because even in the cases where you get 98% of what you wanted or 97% of you want, you know what? The person who got 3%, they're looking for all the loopholes, or they're looking for the way to get you the next time. So yeah, same thing in mediation. I don't love the saying that like everybody walks away equally unhappy, because I don't think that is true. I think that's typically the feeling in a courtroom, right? But I think that it is about compromise. And I think what we try to get to the bottom of is what is really important to you and why, so we can figure out how to shift pieces. Because there's typically somewhere where you can shift. Every issue and every topic isn't going to have equal meaning to both sides.
Well, I think that's a critical point as well. And I think if we were going to be giving sort of some tips to people going into a mediation, really at any point, but certainly as you're getting close to that courtroom door, knowing the priorities of the issues for you, what's of the utmost importance, and what can you give on, and flip that around, because you also probably have insights as to what your husband or your wife, your spouse, also would be prioritizing and what would be less important. Because that's a large part of the win-win, or the at least not lose that you can craft in a mediation, right? What we try to do is have people walk away on both sides with as much of what they would like as possible, and by choosing what they don't have.
Exactly. Exactly. I mean, exactly.
Yeah. And so, if you were going to, talk to someone, talk to my listeners out there who would be getting ready with their attorney to go into a 1-day or a 2-day mediation, and they've got their trial date a couple of weeks down the road, before they were to walk into your offices, what would you tell them? How would you tell them to get ready mentally and emotionally for the process?
I mean, some of the just basics are it's a long day and you typically have downtime. I mean, what I used to tell my clients as a lawyer, it's a long day. There may be a lot going on, but typically we're really prepared walking through the door. So every break and every downtime where the mediator goes into the other room, we're not going to be furiously working on something in our room, because hopefully we're very prepared. There might be some of that, but bring a book, bring something that is like comforting to you. I mean, typically, now people can play on their phones, right? And stuff like that. But I typically say, bring work, bring a book, bring something that brings you comfort. I know one of the bonuses you've talked about with our online mediations, right, is people have pets and different things that in that downtime bring them comfort. But I think that that's important. If you typically lunch and snacks and all of that kind of stuff is part of the day and provided by the mediator or the lawyers or whoever's hosting. But if I need this, or I want this, or this particular thing will be soothing to me. I mean, so just some logistics, personal logistics to take care of, and anticipating it's going to be a long day, 2 5 o'clock day. The worst is when people show up to mediation at 9:30 and they're like, well, I have to be out of here by noon. You're like, well, that's not what we said was going to happen. So being prepared, of what the time frame is, making sure your kids are drop ups, pick offs, animals, all that kind of stuff is covered. So like basic logistics, so you can actually be there, be present, be focused. Having the conversation, either thinking through with yourself if you're a pro se party, but or with your lawyer about the priorities, the list of priorities, what's really important to you. And a go-to for so many people is like, well, the kids are the priority. Well, breaking that down a little bit further into what does that mean to you, versus saying, I want what's best for the kids, or they're our top priority, that's my only issue that I care about. Kind of breaking down very specifically for you what that means. And hopefully you have a lawyer that's having that kind of conversation with you. What does that mean? And you want this schedule. Why is this schedule what you think is best for them? What, that just kind of the deeper, like the more why questions about what it is that's important to you. And then thinking about the areas where like, this really isn't important to me. And I know if I can shift a little bit here, then maybe I can get something over here. Because that's how the negotiations of life work. So why would the negotiations related to divorce and your kids or separation be any different, right?
Right. No, it's very true. And it's, I would say I love, the bringing the things that bring you comfort. I mean, I always would tell people dress comfortably. I always said, bring a book. Now I'd say, have some podcasts teed up.
Yeah.
Not divorce podcasts. Maybe you want to listen to something a little different. A little comedy or something or peaceful music, or calm the app, right? Do a meditation, but also, and I say this to both attorneys and the clients coming in, is everybody, take a deep breath, get off of the adversarial mindset, and everybody just soften into that. Let's see if we can really just bring this to a resolution for everybody. Because sometimes I think we get so caught up at that high level of that vibration of it has to be a win or a lose, that we get lost in that. And so I always, in my introductory remarks to people will say, trust me, I've been here many, many times before when it seemed hopeless. And I know that if we all just take a pause and take a moment, we can find ways that you haven't thought of, or new ways to put the pieces together. So this is going to work for your family.
Yep. I love that. I actually, so a lot of times I'm traveling to law firms, sometimes my place, sometimes, so I actually have these little cards, and as part of my intro, I say, your lawyers know that I'm a serious lawyer, so don't freak out, but your lawyers also know that I am very woo-woo. I am a yogi and I believe in all of that. And if you do too, awesome. If not, take it for what it's worth. But there's a card in my little mediation bag that I take with me to each client that has a Kundalini meditation that I tell people throughout today, when it gets to be 3 o'clock and everybody's clenching their fist and feeling like they've been giving all day and the other side hasn't. It's a Kundalini meditation, and it's just peace begins with me. And you just touch your thumb to each finger, and you can do it under the table. You can do it in the car when you're mad at somebody. You can say it out loud. You can say it to yourself. But if you actually just take even just a minute to do that, it will calm you down. So that's actually something that I share with my clients as well, as kind of something that will help them regroup throughout the day if they need it.
Well, I've done that because you did that in a training that we did together. And I wonder, would you be willing to share that with my listeners?
Absolutely. Sure. Yes.
I think so. Everybody, I'll get the information from Claire as to how we can share that. Be looking in the show notes, and we'll have information, because I know exactly what she's talking about. And really, it is a tool you can use, not just in your mediation. You can use it at all times. Face it, we live in stressful days these days. I could have used it this past weekend. I know.
Yes.
I was just telling Claire about my crazy weekend. So, we all need these times. But ultimately, at a high level, I know what you've just done in this episode, Claire, is given so many people hope, and you've been shining a light on the fact that no matter what, it is never too late to mediate, and that it can be done, and that it takes someone to be brave enough to bring up the idea, even if it's been talked about before in your case, even if it was the other side, your spouse or their attorney said no. Try one more time. There are benefits for all of you. And there are attorneys like Claire out there who are now mediating, who bring that wealth and skill to the table, and every day help people resolve their divorce, whether it's at the beginning or on the courtroom steps. Right, Claire?
Absolutely.
So Claire, how can people get in touch with you?
So my website is clairesamuelslaw.com, and I'm on Facebook and social media, Claire Samuels Law, and LinkedIn. I am not on Twitter. I need to, but I'm not.
I'm on it, but I don't pay much attention to it. Yeah. I'm not snarky enough for Twitter, is what I say. People are funnier than I am on Twitter.
Yeah, but there's lots of good information on my website, how to get in touch with me, resources, things that I share with clients. Susan's podcast is on there, and just lots of good stuff. So that's the best way to find me.
And definitely follow Claire on Instagram. I follow her on Instagram. She has a wonderful feed with all kinds of great tips, and also just little insights into her beautiful practice. It's called A Becoming Divorce. She has a wonderful practice that she has set up, and a curated community. If you are in North Carolina, in her area, please, please, please check it out, because there are resources. Claire is there, and then more resources than you can possibly imagine. And she's really, you have created something beautiful there, your community, Claire. So I thank you so much for taking time with my audience today. I know that you have been shining a light for people today.
Oh, thank you so much, Susan. It was really so great to be here, and such an honor to spend time with you and your listeners. And I really appreciate it.
And you'll be able all to meditate and touch your fingers soon. So
exactly. Peace begins with all of you.
Oh, I love it. Thank you, Claire.
Thanks.